Well, good afternoon, everyone, and thank you for attending today's webinar entitled Winning in Overtime, How to Save Money and Protect Your Business by Ensuring Compliance with the Wage and Hour Laws. My name is Bernie Fuhs, and I'll be moderating today's webinar. I am a shareholder and business litigation attorney with Butzel Long. In addition to today's hot topic, I am also a member of our non-compete and trade secret specialty team and a founding member of the firm's franchise specialty team. Now, my apologies ahead of time for the cheesy title. I am a former basketball player, so I couldn't resist the old sports overtime analogy. As much as I can, Brett and I are going to try to liven up wage and hour law as much as you really can.
Yeah, if that's possible.
Exactly. So presenting with me today is my colleague and our resident labor and employment expert / guru, Brett Miller. Brett is located in our Detroit office and concentrates his practice in labor and employment, including the FLSA issues we are going to be talking about today. Brett is also a founding member, along with myself, of our franchise specialty team. So a few quick administrative things at the outset. Before we begin the webinar, I just want to remind everyone on the call to please feel free to submit any questions you might have about today's content through the GoToWebinar question panel. Brett and I will do our best to answer your questions at the end of the webinar, time permitting. In the event we run out of time, we will be sure to reach out to you individually. And we've already been fielding questions even ahead of today's webinar, so we've got a number of questions that have been pre-submitted that we're going to try to answer at the end. And again, if we have time, we'll get to any more questions that we have. Finally, if you'd like a copy of today's presentation, it will be available on the Butzel Long website later today. Just go to the webinar event page on butzel.com, and a link will be there for you to download a copy. The webinar is also being recorded, and you'll be able to access a copy of the recording in the future by clicking on our YouTube icon on the butzel.com website. And you know you've arrived when you have your own YouTube channel.
That's right.
So once again, thanks to everyone on the call for attending today's webinar, and let's get started. So suffice it to say, this is an extremely hot topic. Brett and myself have been fielding questions from numerous clients and prospective clients about compliance with overtime, wage and hour laws, and all the goodies we're going to be talking about today. We were fielding these questions before November 22nd, and even more so after November 22nd, which there was a ruling addressing these new regulations going into effect. And now we're in what we call a quote-unquote limbo stage. So we're going to get into all that, address as many hot topics as we can, and a lot of the questions that I know you on the call have. So before we get into the nitty-gritty, I'd like to kind of just start with a quick refresher overview for those on the webinar to make sure we're all starting on the same page and make sure there's a basic understanding of the FLSA. So if you could walk us through kind of some basic principles to make sure we're all on the same page, so to speak.
Yeah, that's right, Bernie. I mean, we're going to be talking about some general overview today. You also mentioned the new regulations, and I think it does help to start kind of from the beginning in terms of demystifying what we're talking about when we get into some of these terms, some of these laws. And the Fair Labor Standards Act is the main federal law, of course, that governs what we're going to be talking about in terms of wage and hour laws and talking about non-exempt employees and exempt employees. And that's where we see these new regulations that have been delayed. But really, non-exempt at its very basic level means that someone who earns minimum wage and overtime under federal wage and hour laws. An exempt employee is, of course, someone who is exempt from those requirements if you meet certain tests. And this is where we get a lot of questions, Bernie. So we want to spend some time on exempt employees and these tests: salary level test, salary basis, and the duties test. Sometimes people have a couple of these down, but they'll miss the duties, or they'll have the duties test down, but they don't have the salary basis. And with the new regulations that were supposed to come into effect, we've had a lot of focus on the salary basis without a lot of focus on the duties in some cases. So we'll go through all of it, but starting from the beginning, there is a salary level test. Currently, we think at least, employees who are paid less than $23,600 per year, it's about $455 a week, meet the duties test we'll talk about later, are not exempt. It means no overtime, no minimum wage if you are an exempt employee. Over $100,000 a year is generally exempt for office and non-manual work. Now, of course, we'll talk about the new regulations that were supposed to be in effect December 1st that would have increased these levels. But for now, and since 2004, this has been the salary level test that we talk about. When we mention a salary basis, we talk about what you think of the salary. You get a predetermined rate that is not supposed to change, except when it does. On some kind of weekly fluctuation, you get a salary. It's going to be $1,000 a week or $1,500 a week or whatever it is, as long as that's what you're going to be paid frequently. It's not supposed to be reduced for quantity or quality of work, and that's where we get into, again, we get a lot of questions on that, and we'll go over some of it. And you have to be paid the full salary in the work week. If you don't perform any work in a week as a salaried exempt employee, you don't have to be paid for that week. But someone comes into work for a half hour on a Monday morning, checks a few emails, and leaves, the general rule is they get their salary for the whole week. So we get a lot of questions on how we deal with employees in those circumstances. Now there are some, this is where we start to get a little confusing. And again, we're doing a general overview of this law that has thousands of pages of regulations and case law decisions, but we'll get some of the basics. There are no salary level threshold, that 23,000 and change we talked about, for certain jobs like outside sales, doctors, lawyers, teachers, or certain computer-related professionals. We had a lot of questions when the new regulations were looking like they were going to be fully in effect on December 1st about outside salespeople who weren't meeting that new threshold. And whether it's the current regulations or new regulations, there'd still be no minimum salary level that would apply to an outside salesperson. So we get a lot of those concerns. So I wanted to address that.
So we've talked quickly about obviously the salary level test, the salary basis test, and we just touched on no salary requirements. But I mean, let's get into some of the meat of it right now. I mean, I think everybody on the call knows that some new regulations were being sought to be implemented, and that's kind of been stalled, so to speak. Can you just get into and talk about the regulations that were supposed to be implemented and what's happened, since November 22nd?
Yeah, I think a lot of the the individuals on the call have been in the loop on the DOL's proposed new overtime regulations. They were to go into effect December 1st, as we mentioned, and it would have increased that 23,600 number of the salary level I told you about to 47,476, or about $913 a week. Obviously, that's a huge increase from where you were. And anybody who was earning a salary between the 23,000 and now 47,500 approximately was going to have to look at either getting a raise or going into an hourly role and being paid overtime, or some kind of other maybe reduction in hours, some kind of strategy to address that. And it was all hands on deck for a lot of employers leading up to December 1st, trying to figure out how to deal with these regulations. The salary level then was even supposed to increase every couple of years, so that we're talking about, to be exempt by 2020, the estimates where you'd be making $51,000 a year to have to even be exempt for some of these roles. And that, for small businesses, for companies who have employees in places other than New York City or Los Angeles, where you might have higher salaries, this was a huge deal. So the compliance, as mentioned, was supposed to go into effect about a week ago. And then we got a kind of surprise decision out of a judge in Texas who issued a nationwide injunction saying, you know what, I think the Department of Labor has overstepped its bounds on this one. I mean, going from $455 a week to over $900 a week on a rule that was originally supposed to have this very low salary level test to get you in the door on this non-exempt is just too far. And he issued a nationwide preliminary injunction, which means it's a temporary injunction, but it effectively halted implementation of the new rule. Now, the Department of Labor did appeal this decision on December 1st, the day that these regs were supposed to go into effect. The briefing schedule that is before the Fifth Circuit now on this appeal actually doesn't complete briefing until after January 20th for the inauguration for President-elect Trump.
Well, given that this has happened, obviously some of the folks that are on the call right now and our clients have already taken steps to implement these changes that they thought were going to take effect. Some haven't because of this ruling, and rightfully so in many ways, because it is a pretty big burden. So I guess the question is, what do our clients and prospective clients and employers, whether they're franchisors, franchisees, you name it, mom and pops, Fortune 500, what did they do during this quote unquote limbo stage? Because obviously it was supposed to go into effect December 1st. Do you just proactively comply with it, but knowing with the new administration that's taking over January, do you kind of take your chances and not do anything with the hopes that this is going to be rolled back?
Sure. And that's a great question, Brandon. There's a risk, right? When the new home care regulations went into effect under the Fair Labor Standards Act and were for a while shot down by a federal court, 10 months later, an appeals court overturned it and said, guess what? The rules are also now retroactive for the last 10 months. We don't see that happening here since this is a preliminary injunction as opposed to an outright denial that the whole entire case is dismissed and the regulations are dismissed. But there's a risk. Employees have been, in many cases, promised that they're going to get a raise so that they can meet this new salary threshold. If you're a business owner or an employer and you say, okay, guys, I know we told you December 1st you were going to go up to $47,476, but just kidding, we're going to put you back down to $35,000 or whatever. There's a huge HR concern for that. There are just few options. You can put your compliance plans on hold if you haven't implemented them yet and say, look, there's some questions about this law. Everything's up in the air. We're going to maintain a status quo for now. You could try to roll back what's already been done. Again, there's some legal risks involved in that, but that's an option, particularly if people have been made hourly solely on the basis that they're not going to meet the new threshold. And maybe you roll that back. You can keep them on their salary level for a little while longer. Or you can leave compliance steps that are already in effect. A lot of people, if you're making $46,000 a year and you bump them up to the $47,476, you're probably not going to then just take that away. So, it really depends on the business and the morale issues. But, as a practical matter, those are a few options.
And really, I just want to, if we can go back to that slide, Brett, I really want to emphasize this to the audience. Look, these are the three options, okay? Put their compliance plans on hold. Number two, roll back the compliance steps already taken. Or three, leave the steps that have already been put into effect. This is the classic lawyer answer, but it is, to the folks on the call, the answer is it depends. And we'll get into this as we go through the presentation, and obviously after. This whole presentation is kind of an overview, letting you know what the lay of the land is. But each employer is most likely in a different industry and has different needs, different employee levels, things like that, and are at different stages in the process. So these are your three options. We encourage you, whether it's obviously us or your respective attorneys in the states that you predominantly work in, go to them, lay it out, and then those attorneys can kind of guide you as to what option would be the best for you and your team.
Yeah, that's kind of a good theme for the FLSA in general. It depends. There's a lot of moving parts to this, including this regulation. And it is a temporary injunction. That case in Texas is still going on. Now, the Department of Labor has issued a kind of an emergency appeal to appeal this temporary nature of it. But the court still would have to rule on a permanent injunction. There's a motion to dismiss or for summary judgment pending by the business interests in that case to say, you know what, judge, throw out the entire regs, kick them, declare outright that they're illegal and that this injunction is going to be more than an injunction. It's going to be, a punch in the face to the Department of Labor that you've issued unlawful regulations. That could be ruled on at any time, even before the inauguration. And once President-elect Trump is inaugurated, there's been a lot of speculation on what might happen with these regulations, Bernie.
I mean, look, predictability in our industry and frankly with many things these days, including the recent election, is tough. And you and I are not in the business of making predictions. If we were, and we were right, we'd be in a different business. But, with the president-elect, I mean, it's hard to predict what he's going to do. I mean, we don't even know, what he's going to tweet later today. I mean, you just don't know. But, with your experience and what you've seen in terms of what he's been doing, in terms of with his transition team and everything else, I mean, any insight? What does your gut tell you, Brett, in terms of what he's likely going to do or what his administration is going to do with all of this? I mean, do you have a feel? Because that may provide at least some kind of guidance to our clients and those on the call.
Oh, put me on the spot, Bernie. That's a tough one. I think there's a lot of debate out there right now. My gut, no promises, but my gut instinct is that the new administration is going to either request that the injunction remain in place pending new rules or pull the regs completely and issue new rules. So that would be something more of a compromise than what we see with the current regs. Maybe you see a salary level that isn't as high as the $47,500, and maybe something in the low 30s or scaled, and maybe some different rules for small businesses and more rural businesses, because Trump did make some comments during the campaign on how unfair it was to apply this one-size-fits-all solution to businesses of all sizes in any state. Like I said, if you're in New York City or the Upper Peninsula of Michigan, you're going to be paying the same salary to your threshold level to your employees. It seems unfair. So I could see some changes going that way, but I don't think that it's going to be absolutely status quo for too long.
All right.
We'll see something.
Well, that's the best we can ask for. That was a tough question. I apologize.
No pressure.
With that one.
No
yeah,
pressure.
No pressure. Well, let's kind of move into, this is one of the more common questions I've fielded, and I think you have as well. It's, let's say you have someone who is exempt and paid a salary, but there is a need to deduct from their pay for, let's say, time missed or some other reason. To those on the call and our prospective clients, I mean, what are the rules and how do you navigate where, I guess the question is, to deduct or not to deduct in those kind of situations?
Right. And Bernie, remember that we talked about the first step you've got to prove to make sure your employee is really exempt is that they're making that salary level we talked about and they're paid on that salary basis. In other words, you're supposed to be paid that same salary for any time you work during the week, except when you're not. As I said, there are exceptions. And one of the general rules to keep in mind is that when an employee is ready, willing, and able to work, and they're providing work in that work week, you can't deduct pay for time when work is not otherwise available. If that employee is ready to go.
Okay, well, let's kind of put it to the test real quick. I mean, let's say we've got a client or a prospective client or an employer out there who has a factory. And let's say the factory's in Michigan and it's the first snow of the year. Let's call it the proverbial blizzard. It could be 1 inch, it could be 10 inches. In Michigan, if it's the first snow, everybody thinks it's a blizzard.
And forgets how to drive.
Exactly. But let's say there's a blizzard and the employee who works in the factory, despite the blizzard, thinks he or she can get into the car and they can make it to work and they're ready, willing, and able to work. But for whatever reason, because of the blizzard, the employer who runs the factory decides to shut down the factory during that day or during that week, have you. But the employee makes the argument, hey, I'm ready, willing, and able to work. I'm willing to drive my tractor through the blizzard to make it to work. Do you have to pay him or her?
Well, as I said, the Fair Labor Standards Act is somewhat complicated, so I'll take it one at a time. Let's say it's a 1-day shutdown due to the blizzard, and you have an exempt employee. If the plant is closed and the employee wants to make it in, you've got to pay that employee. They're ready and able to work. It's you, the business owner, that's not. If the situation is reversed, if the plant is open and say, hey, we need everybody to come in, and the employee, the exempt employee, calls in and says, I need a snow day, I can't make it. You don't have to pay them for that day because that is a personal day for that employee. They are not ready and willing and able to work that day. Remember, though, if the plant is shut down for some reason for an entire week, the exempt employees only get paid in a work week where they've provided some work. So if they do no work in a week, they don't have to get paid. Absence, there may be vacation or PTO that could come into play, but that's the general rule. The tricky part, of course, in the modern era is if you got an employee checking their iPhone email for their work, they're providing work that day, and you'd have to pay them. There's also, of course, morale considerations that go into: are you going to dock the guy that's worked every Saturday for the past 6 months because he didn't come in on Friday for the snow day? From a non-exempt hourly employee standpoint, you don't have to pay employees if they're not working. You pay them by the hour they worked. There may be PTO policies that could come into effect in inclement weather, but if it's just an hourly person, they're not going to get paid in that situation. So, as I said, the general rule is that you pay an exempt salaried employee, for all hours that they work in a work week, except when you don't. And that kind of gets into, there are exceptions to this. And right. The Fair Labor Standards Act has exceptions to the exceptions to the exceptions. I mean, we could talk about this for days, but there are 7 real, I think, key no pay docking rules that we look at when we're talking about exempt employees under the FLSA, Bernie. And I'll go through a few of those. So number 1, absences from work for 1 or more days for personal reasons. The example you just gave, that question, is a perfect example. If the employee misses work when the plant is open and it's the employee's choice not to go into work, that's a personal day not occasioned by sick or disability, so you wouldn't have to pay that day. But other times you might have an absence for work for 1 or more full days due to sickness or disability. If that is a missed day pursuant to a bona fide sick leave plan or policy or some kind of PTO plan where you have a wage replacement, you can use the PTO or that wage replacement instead of having to pay them the salary for that day. So you can dock a PTO bank. There are rules specifically for military pay or jury duty witness fees that exempt employees can have some pay docked for that. There are penalties that you can impose for really violating a safety rule that's quote unquote of major significance. I don't like to talk about this one, Bernie. It's fraught with peril. I wouldn't to have to prove that there was some safety rule violated of major significance to dock pay. You're going to spend more time and effort fighting the lawsuit or administrative charge on that than just paying them for the day. So I don't like to recommend that rule. But you can dock pay for an unpaid disciplinary suspension as long as it's for more than 1 full day. In good faith, if there's been some kind of work rule violation, you suspended somebody for getting in a fight or doing whatever and sent them home for a few days. Those kind of suspensions you can enforce. Proportionate part of employees' full salary may be paid for time actually worked in the first and last weeks of employment. If you start work on a Wednesday and you quit on a Tuesday, you don't have to be paid for those full weeks. You would have that prorated from the Wednesday start date and the Tuesday quit date, even if you're a salaried employee. Now, one of the few areas where you can dock an exempt employee's pay for less than a full day is when there's some sort of Family Medical Leave Act implication. Employees on intermittent Family Medical Leave Act, they need to take off the afternoon for a doctor's appointment. If your policies allow for this and you have certain timekeeping that's in a lower than a half-day increment or lower, you can dock them for less than a full day in that case. But Bernie, it's really important to be careful with this, because if you dock an exempt employee's pay improperly, you can not only destroy the exemption for that employee, you can destroy it for the entire job classification.
Mm.
So if you have a couple, managers that you are docking their pay improperly for, all those managers, not just that one, can suddenly lose the exemption if you don't have some procedures in place and if you're not careful. So the no pay docking rules, there are these exceptions, but employers need to be really careful, or else they could end up having a bunch of formerly exempt employees coming after you for overtime and demanding that extra pay.
We'll get into obviously some of the risks and things like that, but would it be a fair piece of guidance and advice to say, if all else fails, err on the side of payment?
Yeah, I agree. And a lot of employers will do that because of the legal complications and the difficulty that you can run into in trying to make sure that you are docking the time appropriately and documenting why you did any deduction. And then, as we mentioned, the morale reasons. I mean, if you're an employee working 7 days a week sometimes, and you've got to take a day off here or there, and they're going to dock your salary, that employee is probably not going to be working the weekends anymore.
I mean, this also goes to, it's a little bit off topic, but look, when employees leave, whether they're going to a new job or somewhere else, or there's some, and I see this a lot in litigation when someone wants to enforce a non-compete or some kind of post-employment restriction, and they find out someone engaged in some wrongful activity, whatever it may be. And there's always an impetus by the client or prospective client to say, well, I don't want to pay him or her that last month or those final 2 weeks because they wronged me. And our guidance at that point is typically, that's great, but if you want to enforce your post-employment restrictions, pay that person through those 2 weeks, because if you don't, it's a small amount of money, but it can give you a whole bunch of trouble down the line, and it gives them an out from those restrictions if you don't pay.
Yeah, that's a great point. I mean, there are a lot of considerations from enforcing restrictive covenants after someone leaves to, are you improperly destroying an exemption for classification of employees and workers? I mean, the consequences of messing this up can be huge. And it goes into not just the salary basis that we talked about, which is only one step in determining whether someone can be exempt. We get a lot of questions from employees beyond the salary deductions and what they have to be paid into whether they meet that second part of the test we talked about, the duties test.
And what is, we've talked about employees meeting the actual duties test to be exempt. Let's break it down. What does that mean?
Right, and at its most basic level, Bernie, it's, you've got to be paid the salary basis that we talked about. And then you also have to actually perform certain job functions that fall into the statutory criteria that allow you to be exempt, that allow you to avoid overtime and minimum wage and actually earn that salary. And there are three main exemptions that we look at for the duties test that the law allows. We'll talk about some other kind of interesting notes, but the three main ones are the administrative exemption, the executive, and the learned professional or professional exemption. These are the most common that we talk about someone being exempt and able to earn a salary. But what we found is a lot of the employees or employers aren't necessarily checking these. So for instance, the administrative exemption, okay? There are very detailed rules on how this is applied. Has to be typically high-level employee whose main job is to keep the business running. And it's not just the operational or production employee. It's the person who's formulating, interpreting policies, has the authority to commit the company financially, or if need be, deviate from policy. There are numerous examples in the regulations of people who tend to fall under this category. And as you can see, there are rules of thumb that you follow, but there are really specific carve-outs for this. So to the extent that you are involved in the management functions, we're talking about personnel who are involved in tax, finance, budgeting, human resource management, an HR manager who interprets or implements employment policies would be a perfect example. Maybe a purchasing agent who has the authority to decide which fleet of vehicles to buy for the company. That would be an exempt position. The administrative assistant who decides which rental car you're going to get in your next business trip is not going to be an exempt one. So you see kind of these distinctions under the administrative exemption. We hear a lot about the executive exemption as well, which is another one. This is your typical manager exemption. Someone who regularly supervises 2 or more employees. They have to actually have management as a primary duty of the position. And generally, they're the ones who have the ability to hire or fire some of these employees. That, what you would think of as a general manager. Rule of thumb on an executive is determine if who the employee is who's in charge of the department or subdivision. Typically, a shift, the shift supervisor. If someone called you and said, I need to talk to the manager or the boss or the supervisor, who would you transfer that person to? That's usually the one who's going to be actually exempt. Simply calling someone a manager without any of these responsibilities is not going to save you in a lawsuit down the line. And they actually have to have managerial duties customarily recognized in the department or subdivision. You can't make up that, you are the manager of the Bernie Fuhs department and
Right.
therefore you're in charge. It has to be something more tangible. Learned professionals are, sometimes you would think this is a fairly straightforward one. We're talking about doctors and lawyers, but it can get confusing. I mean, it's someone who has primary duty in utilizing advanced knowledge or skill in the field of science or learning. Typically, it requires a degree. There are some exceptions, of course, but you usually are looking at people who have some prolonged course of specialized instruction.
We talked about lawyers, doctors, those are ones that stand out. I mean, can you give us some examples of ones who are not so, typical and off the top of the head like that?
Sure, I've had some examples that we've included here from actual clients in the realm of healthcare and social workers, right? So social work can perform a lot of different functions with the degrees. So here's one with a master's degree in social work. The job required 2 years of experience, independent decisions about the course of therapy best suited to the needs of any clients, patients, individuals. And then they were also supposed to be helping diagnose problems and put forward a treatment plan. So what do you think? Would that social worker fall under a learned professional, Bernie?
Well, you're the expert, my friend. You tell me.
In that case, it did. It did, master's degree in social work, and then this sort of independent judgment that is using that advanced knowledge was a learned professional. Contrast that with a caseworker who only has a bachelor's degree in social science. That's job was to train volunteers and run classes and refer patients to other community services, unlike the last person who was actually analyzing and diagnosing those patients. This is more of a referral. And they could provide some in-home assessments, but it's really more of therapy and counseling and not the diagnosis and high-end advanced knowledge. So in this case, this person was not exempt. This was an hourly employee. The bachelor's degree in the job didn't require that advanced skill or knowledge to get you there. So you can see that sometimes when you're just talking about lawyers, teachers, accountants, pharmacists, engineers, you can think it's a pretty clear-cut case. But when you actually get down into some of these subcategories or employees that are performing some of these mixed jobs, it can get pretty confusing. So that it's certainly something where
Who would be non-exempt professionals? Can you give us some examples of those?
Yeah, there are several, So, we talked about high-end accounting as a learned, CPA is a learned professional, but the clerks who do accounting, just someone who's a bookkeeper, is going to be hourly. They're non-exempt. Cooks who do food prep are going to be non-exempt. You have to pay them hourly and overtime, as opposed to the chef who handles more, makes the decisions, and got an advanced degree. Those individuals would be exempt. Paralegals and legal assistants, non-exempt. Engineering technicians would be non-exempt. You have to pay them overtime, as opposed to a high-level engineer with an advanced degree. That person would be exempt. So sometimes even within the same field, depending on the job duties, you're seeing professionals who are also non-exempt.
Well, we've got a lot of employers, franchisees who are on the call as well, and they have, let's say they're in the moving industry, and they have their general movers who are out there actually going to your house, moving the furniture, doing those kind of things. Would those be non-exempt employees, in your opinion?
Yeah. The kind of manual labor, non-office work where they don't have any supervisory authority, it doesn't require an advanced degree. A mover is going to be a non-exempt employee, typically under the administrative regulations that we saw in terms of our salary. But as we've mentioned, there are some exemptions where a mover or a driver can qualify for an exemption from overtime, not minimum wage, but can qualify for an exemption for overtime in certain circumstances under the motor carrier exemption, right? So the first step is you go through the process, administrative, executive, learned, professional we looked at. And then you have to see if there's any of these other little niche laws that can apply to the industry. And a mover is a perfect example because if someone is involved in interstate commerce, if they are a driver loader that is affecting safety within interstate commerce, and they are driving larger vehicles over 10,000 pounds or helping load those larger vehicles, they can have this so-called motor carrier exemption to be exempted from the overtime requirements.
And just to be clear, I mean, this obviously applies to the moving industry, but as you mentioned, I want to highlight, I mean, anybody who's distributing things in interstate commerce that even has some kind of fleet in terms of distributing these things across state lines, your movers, those kind of folks, this would apply to you.
It can, and the motor carrier exemption gets very complicated. There are rules on when you're going in interstate commerce, if you're not going in interstate commerce, what you have to do. But the general rule is, for instance, a common problem we see is if you're a loader, simply loading is not necessarily going to get you into the motor carrier exemption. But if you are a loader who's responsible for the proper loading of a vehicle, then you can get the motor carrier exemption for that loader, even though they're not driving in interstate commerce, but maybe they're the mover that's loading it up and then unloading it when you get to the destination from where you're moving. But the key in crafting that job description is that they should be helping proper loading of the vehicle, weight distribution, putting the furniture or whatever you're moving in a place that's not going to fall on you and give you a concussion as soon as you open the doors. And if you can craft your policies that way in your job description, you can get the loader involved in a motor carrier exemption, as well as the mechanic that works on the vehicle that's going in interstate commerce. As long as it's part of the safety, you can utilize this motor carrier exemption. We're dealing with a lawsuit looking at the very nitty-gritty issues of a motor carrier exemption case right now, and one of the things the other side is arguing is on this aspect of was the loading done to meet safety standards, or someone just throwing stuff into a truck without any kind of training, any kind of policies on that. And so that can be a real key area when you're looking at this exemption.
And I think an important thing here is that we're getting to some nuanced examples of the exemptions and the exemptions to the exemptions. And I think it's important for the folks on the webinar that, look, this is very industry specific many times. And again, Brett and I can only provide this overview in less than an hour. So it's going to be important after this call that you reach out to your direct attorneys and go over these issues, because what applies to someone who's involved in moving and interstate commerce might not apply to someone who is involved in sales and things like that. So, actually thinking about sales, I mean, what do we do? We've talked about movers and motor carriers. What about folks who have a sales force and are paying folks primarily or in large part based upon commissions? Any guidance for those?
Well, outside sales commissions, outside sales personnel fall under a separate exemption. If they are truly outside sales, they can be exempt and paid salary. Your typical example of that is sort of the pharmaceutical sales rep there is no office, they're in a doctor's office somewhere trying to sell medications, right? Outside sales. Your question and talk about industry specific, when you look at inside sales, commission employees who are doing something within the company, that gets pretty complicated. There are some rules on when you can pay commissions to employees in a retail establishment. The regulations get hyper technical on what that really means, but suffice it to say, the regulations provided laundry list of entities that do not qualify under the retail establishment rule. And some of those include, you mentioned movers a moment ago, common carriers or contract carriers, transportation companies. So in that case, commissions in the regulations expressly do not apply. Burglar alarm installation, for instance, is one where the commission structure would not apply to be exempt. There are rules that if you're going to pay commissions to these individuals, it has to be a time and 1.5 times the minimum wage rate. The compensation for the commissions has to make up 50% or more of their pay. So we see some common problems with commissions. Either they don't meet the retail establishment definition. Sometimes employers forget about the 1.5 times the minimum wage rate, or that 50% of the pay made up in commissions. Or sometimes I see employers using tips to calculate commissions, which you can't do. It's separate things. So commissions, you have to be real careful. If you're structuring your pay force or the pay for your workforce under commissions, I would highly recommend talking to your your HR expert or your labor and employment attorney before you do that.
What about fluctuating work weeks? I mean, I've heard a lot about this too in terms of dealing with employees who are salaried, but they got a fluctuating work week. Any general guidance, tips on that end?
Yeah, we've had a lot of questions about fluctuating work week, particularly when the new regulations looked like they were going to be hitting on December 1st. And what fluctuating work week is, Bernie, is essentially if you have an employee who agrees with you ahead of time, who's otherwise completely non-exempt. So you got to pay him overtime. This is a non-exempt employee, but you have them agree that they're going to be paid a salary for all hours worked, no matter how many hours they work. What you do is then you would pay them that salary, which would cover, let's say they're working 45, 50 hours a week. That would cover all those straight time hours. Then at the end of that, you would pay them half time for their overtime. So if they're working 50 hours, you already paid them a flat salary for all 50 hours. You determine the base rate of that and pay them half time for the hours between 40 and 50, those 10 hours. It can get super complicated, but the upshot is you're paying an employee, rather than time and a half, you're paying them half time. Calculations get a little complicated. There's some debate about when you can really use this. The Department of Labor takes the position that your work week must fluctuate every week, sometimes more than 40 hours and sometimes less if you want to use it. The regulations don't say anything about how it has to fluctuate less than 40 hours. That's the Department of Labor's position. So this is another area where we see a lot of litigation if it's not properly applied. So it's something to be careful of, but it is an option for employers to consider.
So we've talked about movers. In general terms, we've talked about people who are paid based upon commissions, your classic sales rep. What about those, including movers, who are paid based in large part, or at least a portion, on tips? Massage therapists, waiters, bartenders, those kind of positions. How do you navigate those waters with folks who are compensated through tips?
Well, first, we get questions on this, and tips are not going to get you out of overtime for non-exempt employees. So, when we're talking about hourly, non-exempt employees here, and you're not going to get around overtime. But where we run into trouble is you have to structure a tip arrangement pretty carefully. There's certain notice requirements we have in the slide that you have to provide to an employee. And what you get out of this is a tip credit that goes towards minimum wage, your minimum wage rate. It's not something that you're going to try to use to get around paying any other wages. It's purely goes to a tip credit. There's ways that you can structure this in a tip pool with other tipped employees, but it again is a fairly limited remedy for employees. And mostly what you see this, of course, is in the restaurant, bar, hospitality industry. But there are pitfalls to that. Bernie, have you ever been to a restaurant and you see something on the menu, a party of 10 or more, mandatory 18% gratuity?
Correct. I avoid those places.
Yes. Right. So
just kidding. I do tip every time, 20%.
Well, would you be surprised to know that that's not actually a tip legally for the employee? If it's a mandatory percentage, it's a service charge that is income to the employer. If they then pay that to the employee, it's not tips. Tips always belong to the employee, not the employer. It's paid as wages to the employee. So I have clients mess this up all the time. That impacts the payroll, it impacts the minimum wage, it impacts the amount that you calculate to pay overtime, because now you're paying them more wages, so you have to recalculate the hourly rate to calculate time and a half. It can get incredibly complicated. So tips are for more of a limited, like you said, niche kind of industries. And even in those industries, there can be a lot of liability if it's not done correctly.
So with all this, I mean, look, you and I represent clients that range from A to Z, mom and pops all the way to Fortune 500 companies, and I do see this attitude sometimes, but I really see it with employers who are really 50 employees and under, or franchisees who are small but they're part of a bigger system, so to speak. And the attitude we sometimes see is, you know what, this isn't a big deal. I'm doing the best I can. I'm paying my people. And look, if I make a mistake every now and then, it's a couple $100, if that. What's the big deal? If I mess up, there's no real big consequences. Joe Schmo who makes $8 an hour isn't going to come after me. I'll correct it later. Why am I being so concerned about this right now? I mean, what is the response? I mean, I know the response. But you, in terms of the legal advice, what's the response to attitudes like that?
Yeah, I think the statistics give you the answer. These Fair Labor Standards Act lawsuits in federal court are up over 450% in the last 15 years or so. They are going up exponentially every year. Plaintiff attorneys love these, because even if, Bernie, your example of, I've got a guy who's owed, couple $100 here or there, that we can fix that. If you have a couple hundred employees who are owed a couple $100, Fair Labor Standards Act allows you to get in with a collective action that can bring in a whole class of these. You get double damages for whatever overtime you're owed, and attorney fees. So plaintiff attorneys love this. They can file a lawsuit, sit there, rack up their fees, and they're going to get the employer is paying them to sue them. It's incredibly frustrating. Not to mention the fact that if you go before the Department of Labor, it's a $1,000 administrative fine per violation, which can mean any time you're running a payroll where you've docked pay improperly, you haven't paid overtime. Not only are you having to face the liability, you're getting hit with a $1,000 per violation fine, which that number would go up if the new regulations actually go into effect. So this is, and these cases are so hard to defend because the burden to maintain the records is on the employer. And every one of these cases, an employee comes in and says, well, I was working off the clock. You don't have any records to disprove it. Now you're in a position where you have to prove a negative legally to defend the lawsuit, and it's not a position an employer wants to be in.
And so the bottom line is, look, what might be $10, what might be $100, what might be perceived as inconvenient red tape, it is more cost efficient, and it's going to save you money in the long run by just dotting your I's, crossing your T's, and make sure you're doing it the right way up front. Because if you don't, it's going to get real expensive real fast, and it's a huge domino effect. And you're going to be spending a heck of a lot more money, figuring it out afterwards if you just wanted to figure it out at the outset. So let's get into, we've gotten some questions from the audience, and I want to kind of get into we've got 10 minutes left, to get some rapid fire wage and hour questions. So first question, can a part-time employee be paid on a salary basis and qualify for exempt status?
The answer is yes, as long as certain tests are met. We talked about the salary basis, the salary level test, and a part-time employee is still going to have to meet those tests. If the new regulations went into effect, it would be harder to do that, right? But at $23,600, you can pay a part-time employee as long as they're meeting that threshold.
Okay, next question. Can we dock the pay of an exempt employee who has only worked a partial day last week but has exhausted all their accrued leave?
The answer to that, and we mentioned Family Medical Leave Act earlier, but absence any kind of Family Medical Leave Act issue is no. You can't really punish them for that, and you can only dock for non-FMLA sick time in full day increments under the regulations. So that's something we get questions on that a lot, Bernie.
Okay. Question, can I deduct a half hour from a non-exempt employee for lunch and do away with the requirement that they punch out for lunch?
Okay, so now we're talking about a non-exempt hourly employee who would normally punch in or out, and you're, instead of making them punch in or out, you're docking a half an hour of their pay automatically. Now, Bernie, I've actually defended several cases like this, and it's legal but not recommended. I mentioned the burden's on you as the employer to prove the record keeping and the hours worked. And what happens with a lot of employers is they say, well, we're going to dock automatically a half hour for lunch. We want you to take your lunch. If you have to work during your lunch, fill out this form and give it to payroll. And that's tough to defend because 9 times out of 10, the employee comes in and says, I didn't know, or they lost the form, I filled it out. With the burden on you as the employer, it's better to make them punch in and out so you have the affirmative records that the employee is responsible for doing that, or else you can face some liability.
All right. Another question. We no longer employ secretaries, assistants. All of our secretaries are now called administrative assistants. Doesn't this mean the administrative exemption applies and they are no longer eligible for overtime pay?
Yeah, it goes back to like calling a manager sticking around. You can't call someone an administrative assistant just to automatically get out of it. There are some administrative assistants who are exempt and who are exempt from overtime, but that's usually the assistant to the CEO who runs the calendar and the operations, for that CEO. The standard legal assistant or receptionist or secretary is not going to meet the definition to be exempt.
All right, how about this one? Look, we got a lot of clients and employers who say, look, I'm running a real tight ship here. I'm barely getting in the black. I'm oftentimes running in the red. I just can't afford to pay overtime. So why don't I just ask the incoming employees to just voluntarily agree that they're exempt status? And as long as they volunteer and agree to it, it's okay.
No, Bert, you can't do it. You can't waive rights under the Fair Labor Standards Act. So even if someone wants to voluntarily say, I'll do this, or you get the same thing with, I'll voluntarily work off the clock, I'm a good employee, I don't need to be paid overtime. The answer is no. You want to comply, or else you're taking a big risk.
Okay, we got another question from one of the companies that are in the moving industry, and their question is it okay to pay a mover a base pay of minimum wage and then have everything else be tip credit?
So the base pay of minimum wage and everything else is tip credit?
Tip credit.
Okay. The tip credit is going to be, see, the minimum wage is going to, what it allows you to do is set a minimum wage that's lower. In some states it can go as low as $2.13 an hour, and then use that tip credit to meet the minimum wage. And one of the problems we see is sometimes states have a higher minimum wage than the federal. So you can use that tip credit to get you up to the minimum wage. So in Michigan, for instance, you could use that credit to get you up to $8.50 an hour mark. But you can't use it to substitute in as wages for time over that. I mean, the money is the employees at that point. They can keep the money, but it doesn't, the tip credit is only to get you to that minimum wage threshold.
Gotcha.
And so if they're working overtime and there's no service charge like we talked about, the tips don't get you around that. You're going to be paying time and a half based on the minimum wage.
Gotcha. How about, let's stick with the moving industry. You got a non-exempt employee's paycheck. Let's say it's a mover again, who's out doing a move, and they damage some property, whether it's a table or something like that. During the move, can you deduct the value of that damage from their paycheck?
That's a real tough question, Bernie, and I hate to give the answer. It depends, but it does. In Michigan, it's very hard to deduct pay from a non-exempt, hourly employee. You have to have their consent for each deduction, absent some very specific circumstances. You can't dock pay without their consent. In other states that don't have those kind of laws that we have in Michigan, you can sometimes do this, but the key is that you, under federal law, you can't dock it below minimum wage. So that's kind of a key consideration there.
Okay, great. Well, we are just about out of time. I want to thank everyone on the call for listening for the hour. If there are any questions Maybe we can get to some right now, but if there are any further questions, please feel free to reach out to us through the webinar or individually to Brett or myself, and we'd be happy to answer those questions offline. And just to re-highlight this, I mean, we could talk about this for a whole week. I mean, people go to school for this stuff, and it's tough. So there's only so much you can get into within 45 to 50 minutes. And this is just a general overview to make you aware of these issues, give you some general guidance about where to go, what to be aware of. And the important thing is after this call is to go to your respective attorneys, whether it's us or someone in your home state, and follow up with them to make sure you are dotting your I's, you are crossing your T's, to make sure you're doing these things the right way. Because yes, these are tedious, they're burdensome, they are annoying, and they seem small, but these small problems can become really big and expensive problems for you and your company down the line. So if you want to save money in the long run, do it right at the outset. Make sure you're dotting your I's again, crossing your T's, and again, you'll be saving you and your client and your company money at the end of the day. So
yeah, and Bernie, to piggyback on that, the Department of Labor, the agency that is tasked with implementing and enforcing the Fair Labor Standards Act, recently settled a grievance from its own employees where it had to pay them $7 million in a settlement for violating the Fair Labor Standards Act.
right.
The agency that is supposed to be in charge of this can't even figure out this law and gets sued for it. So if they're having trouble with it, it's completely understandable that other businesses out there are struggling.
It's the classic do as I say, not as I do kind of regulation. So,
that's right.
And again, I want to re-highlight too that each employer is likely in a different industry, and different industries, there's different rules. I mean, you can be a company that makes wreaths, and there's a different kind of exemption that applies to you for different employees, different sets of facts. So it really is nuanced. It really is employer industry specific. So again, reach out to your attorneys and get the appropriate guidance to help you navigate those waters. Any other questions, Jonathan or Brett?
We had some people asking about copies of the presentation. A PDF of the presentation will be on the event page on Butzel.com later on this afternoon. We're also recording this webinar, and that will be available on our YouTube channel. And I got some messages that there were some audio difficulties towards the end. All that information will be up on the recording message, and we apologize for that.
All right, well, thank you everyone on the call for your time. Brett, thank you very much, and we'll be in touch, and good luck to everyone on the call.
Thank you very much.